Justice Kagan?
Mr. Beck, the various statutes that Hawaii has cited as going to the Bruin Step 2 question, you say they're not close enough, and I guess I want to know why. I mean, I was struck by the fact that there are quite a number of statutes that do exactly what this law does. They flip a default rule as to how explicit consent has to be. You know, they recognize that you don't have a right to go in without consent. You do have a right to go in with consent. And then the question is, how do we determine consent? And what default rule do we start with? And I guess what struck me about these statutes and about how close they are is that that's exactly what each of these statutes did. So why isn't that pretty good evidence under Bruin Step 2 that this is something that states historically have done?
The state is not cited to a single case that is relevantly similar to the one at issue here. We've got basically two sets of laws. One were the anti-poaching laws that dealt with private property that was not open to the public, one. And part of that also is there were exemptions for people to be able to carry firearms onto those lands that for purposes of self-defense. So land that's not open to the public, where you still have a self-defense right, isn't relevantly similar to the law at issue here. And the other sets of laws that have been cited to are black codes. And those can't be relevantly similar. As Justice Kavanaugh said in Rahimi, you know, we've moved away from that history. And in addition, it dealt with a very, discriminating against a very small subsection of society rather than prohibitions on the general right to carry.
Yeah, so let me go back to the first thing. The idea that these are anti-poaching laws. I mean, okay, Hawaii's is not an anti-poaching law, but I suppose I'm sort of stuck on the fact that that doesn't seem to be the relevant similarity. In Rahimi, we said, you can go up a level of generality. You don't have to have a historical twin. There can be differences. In Rahimi, the essential similarity that we thought controlled was just that the guns were being used to protect against people who would be violent with their guns. And, that's a pretty general principle. And here, the general principle is sort of similar. We think that there's a danger of various injuries occurring when you go onto private property with a gun. It might have been in the old days poaching. It might be something else now. But because that's so, we are going to use a default rule that says to the property owner, if you want this, okay, but you have to say you want it. It seems to me the same. It's a different injury. It's not poaching anymore, but it seems to me the same state mechanism, the same kind of state regulation.
Yes, Your Honor, but one dealt with private property that was not open to the public, whereas this law is dealing with private property that's open to the public. And in addition to that, the anti-poaching laws also gave you a right to be able to carry firearms for self-defense. So I just simply don't see how the level of generality there would simply swallow the rule if this court were to accept those anti-poaching laws as being relevantly similar here, Your Honor.
Thank you.
Justice Gorsuch?